probable cause, but I also want to see what else they've done, especially in this case. How many times did this happen? What else? Were other children involved?
Well, this court's investigation into the Gerstein issue and that is going to be a kind of push me, pull you of where that line is, where the police need to take someone in front of a magistrate to get a determination of probable cause, to have the charges read to the person being charged, and to set bail or bond. And that's kind of a balancing act. Gerstein says 48 hours in recognition that you can't always find a magistrate in the middle of the night and other things happen. But there's got to be a point when that magistrate is available that person needs to be taken before them and had their charges read to them to understand why they're being held and maybe post bond. So just a brief factual summary in this case. Mr. Worley was convicted out of the Grundy County Circuit Court, 4 counts of rape of a child and 1 count of attempted rape of a child. The victim in this case was his 7-year-old daughter, KW. KW, after the disclosures were made, was taken to the Child Advocacy Center and a forensic interview was done. The woman who interviewed her was named Miss Fuller. And Ms. Fuller, at the pretrial motion in limine hearing to determine whether or not the forensic interview would meet the qualifications under the statute, which is TCA 24-7-123, admitted that she fell short of the 3 years that would be necessary as required under the statute. And that gets to our first issue. There are 2 grounds under which we argue that the trial court erred. The issue with Ms. Fuller and her 3 years' experience is under plenary review because it was preserved. The other issue that we have is the fact that KW did not authenticate the recording at either the pretrial hearing and did not authenticate it or authenticated it after it was already introduced or played for the jury at trial. And that gets into our second issue, which is that 24-7-123 requires that the child be the person to authenticate the video and be subject to cross-examination. And that gets back to McCoy. And I understand there are probably some questions about why does it matter when that finding is made. And I think in order to do that, we need to go back to State versus McCoy, which was where all of this began. It's cited extensively by the state and myself in our briefs. And McCoy was the case that determined that that statute was constitutional because A, it made the admission of it permissive, so it did not infringe upon the judiciary's power to regulate the evidence that came into its court. It found that the pre-recorded statement was testimonial hearsay, but that it did not violate the Confrontation Clause as long as that child appeared at trial, was available for cross-examination, and the wording in McCoy says that the child must authenticate the video before it is played for the jury.
But it doesn't say it has to be authenticated at trial.
And that's where
It just
McCoy
says it just says the child has to authenticate the video, and the child has to be subject to cross-examination.
And that's where McCoy comes in, because McCoy says the state is permitted to introduce the video recorded statement as long as it is relevant, as long as it meets the requirements of 24-7-123 and also comports with the Tennessee Rules of Evidence. Authentication under Tennessee Rule of Evidence 901 is a question for the trier of fact. The judge is the gatekeeper in the admissibility, meaning that as long as the judge thinks that, or the trial court thinks that a trier of fact could reasonably find that that was authentic or what it purported to be, that it can come into trial. And it goes on to further illustrate a non-exhaustive list, and one of those at the very top is a witness who has knowledge of what the item is what it purports to be. And what 24-7-123 tells us is that to meet that requirement under Tennessee Rules of Evidence, it has to be the child. And this court has found as recently in the petition to rehear on Stegall that the testimony of the forensic interviewer who was also in that video, who is not the one giving the testimonial evidence, is not the person to do that at trial.
What if the child did it at the pretrial hearing, though?
Yeah.
Right. I know you're not conceding that she did in this instance.
I think it's important to make a distinction, as this court did in Stegall, between a child saying that he or she told the truth in the video and the child looking at the video and saying, this is it. Or I think in another case that I read, like the child on the video copying drew a distinctive picture on it.
Yeah, if the child at the so the trial court does in most of these cases the hearing beforehand, and the child takes the stand and either, I just watched the video with everyone, and I think the one you're talking about, I know it's this one because I drew a flower on it,
Excuse me.
authenticates that video. It's then authenticated per the statute by the child, is it not?
Authentication, I think in terms of looking at that, we have to look at how other things are authenticated. There's no exhibit that comes in trial that isn't authenticated by the witness.
So you're
before it
saying that
gets there.
so you're saying that the video actually has to be authenticated twice?
I'm saying that 901 does not, that a trial court's finding that something is authenticated at a motion in limine pre-trial does not relieve the burden of it being presented for authentication before the jury, the trier of fact who is ultimately responsible for the authentication. And I don't think that's, I know there are a lot of things to do in the statute, but I don't think that's a big ask. I don't think it's a big ask to, all they needed to do in this case was have KW testify before the forensic interviewer. You've read the briefs. The evidence was not insubstantial in this case. It's a very low burden, and it's something that is the same thing for any other piece of evidence that comes in. If someone has a picture, for example, and the state is asking a medical examiner, do you remember me showing you a picture of a headless torso in my office the other day? Yes. They would show that picture to the person who is on, the witness who is looking at that picture to validate that that is the picture that was shown. It is a fair and accurate representation. They don't need to be the person who took the picture, but that has to occur before it comes into evidence, and it's no different with the forensic interview in this case.
Well, I mean, I guess I read this statute as the child has to, at some point, authenticate that, yes, I remember doing this, I told the truth, this is the video of the time I spent with person from the center. But at trial, to get in a piece of evidence, to me, the person who made the video, the counselor or the social worker or whatever, they can say, yes, this is the video we took. And that's, I don't read the statute as saying that the child has to authenticate it at trial. They just have to authenticate that that's the video of them giving their story to the worker.
And I would disagree for two reasons. One is McCoy, and McCoy is very explicit, like this is something that is hearsay, it's testimonial hearsay. And in this case, the evidence or the testimony that was given by KW outside of what was presented in that video was not enough to substantiate.
So McCoy says the child has to validate it at trial.
The child has to the child has to validate it before it is played for the jury. Now,
okay, but
any other piece,
it doesn't say at trial.
and that's where the statute comes in. So the statute says before any piece of evidence, the statute changed in 2023. Before it said at trial, which is what is relevant here now, it says at any stage of the criminal proceeding. Before it can be admitted at trial, and then the litany of things, the number one being that the child has to do it. The child has to authenticate the record. The only time that it says pre-trial is the particularized guarantees of trustworthiness. So if you're doing the negative implication doctrine, or I can't remember the Latin phrase for it, that is the only time where it specifies this needs to be done pre-trial. This needs to be done pre-trial. Everything else is before it's admitted at trial. And that puts it on par with every other piece of evidence that comes in at any trial. It's got to be authenticated. And it's not like we're asking something. She's already got to be available in this case, she's already got to be available for cross-examination. Having her testify, yes, this is it, before it's not a high burden. And it's the same thing with the forensic interviewer. We're at a point, the offense date on this case was 2019. And in 2020, the facts of this case would have made an aggravated rape of a child because she was 7 at the time. And that's when it changed from under 13 to under 8. And I know this court takes every case that's before it seriously, but we're at the point where something like this now I could be before you on a death penalty case. And what McCoy states is this is allowed because we understand that it's a lot of times hard for victims, especially that age, to testify twice, and that's why that and the fact that it doesn't interfere on the judiciary, and there's a provision for it in the rules of evidence that it won't violate the confrontation clause as long as these factors are met. And
Let me ask you this.
have to be met.
If you say that it has to be validated by the child at trial, and the state stands up and says, okay, fine, puts the child on the stand, did you give a statement wherever this one was, did they record it? Yes. If you watch that video, yes. Is this it? Yes. And the state says, we have no further questions. How far can you cross-examine that witness?
Well, the video would have to be, I would think the video would have to be played or at least introduced into evidence. I guess they don't have to play it in front of the jury could take it back, but I think the case law states that she has to be available for cross-examination. It doesn't have to be meaningful.
No, that's what I'm saying. The state says we're finished with this witness, and they turn it over to you. They haven't played the video. They've just had someone validate the video. What's your level of cross-examination at that point?
Well, thankfully we have wide open cross in Tennessee. So,
okay.
And that's something for the defense attorney at trial. But I mean, it's not a big ask to follow the statute in that regard.
Well, whether it's a big ask or not, the question is, does the statute and the Confrontation Clause require it? That's the question before the court. So am I hearing you say that McCoy stands for the proposition that Section 123 requires the child witness to authenticate it at trial? Is it McCoy saying that 123 requires that?
I think it's McCoy first saying that it has to satisfy 24/7/123, and then that compounded with Tennessee Rule of Evidence 901. Because under 901, it could be any witness with knowledge of the fact. But it also refers back to 24/7/123, which means the person who has to authenticate it is the child.
So if I'm hearing you correctly, you're saying it's Section 901 and not necessarily McCoy's reading of 123 that requires the authentication at trial.
I don't. That's a good question. I don't. Not that you need my praise. I would say that I think McCoy was developed in recognition that this piece fits narrowly into a couple different rules of evidence, 802 being one of them because it's a hearsay exception that is provided by law. It's not one of the ones that's listed. I'll be honest, as a trial attorney, I never thought anything other than these are the qualifications under 123. This is what's qualified for admission at trial, that the child has to authenticate it, and that's how I read it. So I read it first as the interpretation of the statute means all of these things have to occur at trial with the exception of the one thing that is demarcated as occurring pre-trial. In a matter of time, I believe, I don't know if that's rebuttal or regular time. But
Regular, I think.
Do you have anything else right now?
No.
right. I'll turn it over to the state.
Good afternoon, Your Honors. May it please the court, Davey Douglas on behalf of the state arguing for Caroline Weldon today. And this court should affirm the judgments of the trial courts because the trial court properly admitted the victim's forensic interview. It did not err when it declined to suppress the defendant's statement, and it did not abuse its discretion when sentencing the defendant. And turning first to the issue of the forensic interview, the video does not have to be authenticated twice, which is what the defendant is asking for here. What the statute, McCoy, and this court's precedent make clear is that all the child needs to do is authenticate that video at some point prior to its admission at trial, and it's perfectly acceptable for a child to authenticate that video at a pretrial hearing, which is exactly what we had here. We had all of the parties very aware that we're referring to the forensic interview that's going to be admitted at trial. We had the victim testify, I can't remember her exact words, but it was, I watched the video, it's accurate, it shows what happens, and I told the truth. And under the statute, that is absolutely sufficient. And
I'm sorry to interrupt, but what do you make of the defendant's Rule 901 argument?
I would say that there's no basis for that argument in McCoy that I am aware of, and I don't think that it's an argument that this court or our Supreme Court has ever adopted. And I think McCoy actually sort of speaks to the contrary. It's very explicit that if a witness is available at trial for cross-examination, the Confrontation Clause places no constraints at all on the use of prior testimonial statements. And since McCoy was in fact considering the admissibility of a forensic interview, I think as long as the victim the child authenticates the video and then is available for cross-examination, we don't have a problem under McCoy or Rule of Evidence 901. The statute again makes this sort of very special exception for this type of interview, and the procedures that were followed here are very similar to the procedures that this court has recently affirmed in cases like, for example, State versus Ruzicka. And this is also a very distinguishable case from State versus Stiegel, which was mentioned earlier. In Stiegel, we never actually had the victim testify at all to authenticate the video. She never said it during the pretrial hearing where there was no testimony or evidence at all, and she never said it at trial. All she said was, I told the truth.
Did I read the briefs correctly? Wasn't there also a question in this case, though, of whatever she authenticated wasn't really clear if she was authenticating the same thing the trial court saw in this case? Did I read that correctly in these briefs?
I think you did, Your Honor. I think that was sort of raised, and the transcript of this pretrial hearing makes it really clear that while we don't have something like drawing a flower on a disc or writing initials, all of the parties are in agreement that we're talking about this very specific.
So it's clear, at least all the parties agree, the video the trial court watched is the same video that she authenticated.
That's what the transcript of the hearing reflects.
Okay.
And you had Mr. Worley's attorney who was questioning the victim about specific portions of the video, which seems to indicate he knows that we're talking about the forensic interview. You have the trial court say it's watched the video, and then you have the victim specifically refer to her conversation with Ms. Fuller.
How does that affect the plain error analysis for authentication? It seems like it could be a little problematic if there was a timely objection, like, I object, Your Honor, this is an imposter disc they're trying to enter into evidence. Things can be done at that point to address the problem. What do you do now?
I think we are under the plain error review, and that sets the bar higher for the defendant. He has to show a breach of a clear and unequivocal rule of law, and I don't think he can meet that burden here because there's never been, our Supreme Court and this court have never ever set forth the bright line rule that the witness has to physically authenticate the exact same disc that's going to be played at trial. It's just important that the witness authenticate the substance of what's going to be played at trial, that is the forensic interview. And so again, since there wasn't an objection made here, there wasn't a chance for the state to present the victim with the disc, for example, there's just not been a breach of a clear and unequivocal rule of law, which would preclude plain error relief here. And then, Judge Dyer, I briefly want to touch on your question about the admissibility of the statement and sort of the difference between holding somebody for a reasonable period of time, which the Supreme Court has established as 48 hours, versus holding somebody just to obtain more evidence to support the arrest. We did not have the latter in this case. Investigator Sims had probable cause to arrest the defendant on October 16th when he did, and then the defendant gave his statement less than 24 hours later. This was all part of sort of a reasonable investigation where you've properly detained someone, and then the police are not required to then cease all investigation into the case before presenting the warrant to the court here. What we have was not, this does not run afoul of Gerstein, and this is not the example of what happened in Memphis, where suspects were simply being held to try and gather any evidence to support it. The evidence was already in Investigator Sims' possession here when he arrested the defendant.
So you're saying in any case where there's probable cause at the time, the initial time of detention, that the police could detain the person for up to 48 hours for any reason at all?
No, Your Honor, I'm not saying that. I apologize. That is not what I meant to say.
I knew you weren't saying that. I was trying to set up my next question, which was, when was the affidavit presented in this case? Wasn't it pushing 48 hours?
It was pushing 48 hours, Your
Honor. They
Honor.
were communicating with the magistrate, it seems, by the next morning after the detention. Why the holdup?
It's not entirely clear from the record why there was a holdup. We just know we have Investigator Sims' testimony that he decided to charge the defendant with 3 counts of rape of a child, and then he contacted, I believe, his superior. And then his superior testified a little bit about the procedure they employed. But what was notable is that the state made the General Sessions judge available to the defense, and the defense specifically chose not to call the judge at the suppression hearing. They sort of backed away from any challenge to any irregularity that may have occurred with the bail or bond being set here. But since we, again, at least had something that went before a judge within 48 hours, this was not an example of the police improperly detaining somebody simply for the sake of delay or to find evidence to make their case. And
So it seems like you're saying, or you're arguing, that as long as the police, the state, is making attempts to be in contact with, to get the defendant in front of a judge within that 48-hour period, and for whatever reason there's a holdup, as long as they're moving forward with trying to get that done, that's going to cure any potential issue, as opposed to, again, the Memphis issue, which was much different.
yes, Your Honor, it would cure any potential issue. And then even more specifically here, we just don't have a constitutional violation that would have ripened before the defendant gave his second incriminating statement. He gave that, I believe, about 22 or 24 hours after his initial arrest. And so if we've got police who are attempting to get the defendant before a judge to get that warrant seen and not simply holding a defendant for the sake of delay or just to further their investigation, we don't have a constitutional problem here. Judge Hickson, again, I want to thank you for the life raft. I was not saying that the police can simply hold someone for up to 48 hours.
I mean, that would be outrageous, right?
It would.
It's
It would.
really outrageous when they have a stamp that says 48-hour hold.
But thankfully, that was not what happened here. This was just a reasonable continuation of the investigation. And unless there are...
Well, let's talk about the,
Qualifications.
yes, thank
Yeah,
you.
thank you. That's what
The
I was.
qualifications of the interviewer. So she was a couple months shy of meeting the true definition of a forensic interviewer. The statute does have what I would call a catch-all to that kind of description, being other work comparable with children, or,
It says forensic interviewing or other comparable work with children.
yeah. How does how do we get there from where she is to meeting that? Because that's the line that gets you there. There's nothing, she doesn't mean anything else in the statute. So you got to get there with that line. How do you get there?
I think we get there from her testimony at the pretrial hearing, where she did actually very specifically talk about the similarities between her role as a teacher and her role as a forensic interviewer. She explained that in both roles, she was there to talk to children, she was there to listen to them, to gather information, and most importantly, to figure out what to do going forward. And
Forensic interviewing, from what I recall from my trial judge days, they have a lot of real specifically taught techniques about how not to lead and all the things that you're supposed to do properly to qualify as a forensic interviewer. And I didn't see anything in the briefs or the little bit of the record I looked at that being a kindergarten teacher had any such tight parameters.
I don't think there is anything about being a kindergarten teacher where you're specifically instructed not to ask leading questions when you're talking to students. But I think what the trial court sort of emphasized is that you are talking to younger children on their level as children. You have to relate to them on their level, which is what you have to do as a forensic interviewer as well. And what this court has also emphasized, and this was in, I believe, State versus Clymer, which is in the defense brief, that the most important aspect, or one of the most important aspects of a forensic interview, is the trustworthiness. And so somebody who had a job where they worked for, I believe it was the Tennessee Disability Coalition, which involved working with children with brain injuries and their families, talking to them and obtaining resources for them, that was enough to be comparable.
So do you think, though, you're arguing about her time as a kindergarten teacher, I mean, if she had 5 years of that and no training whatsoever as a forensic interviewer, would that count? Or do you think, I'm kind of playing devil's advocate to Judge Ayer's question, the fact that she had 2 years and X number of months of actual forensic interviewing training, coupled with her time as a kindergarten teacher, kept her from maybe asking leading questions? I mean, or would you just say that her experience as a kindergarten teacher was enough?
I think I would have two potential answers to that question, Judge Dyer, and I apologize for that. But the language of the statute doesn't actually give us sort of a temporal line like the defendant references in the reply brief. And it's not something that I've seen this court do either. That being said, I think it absolutely, the time that you spend in this job that's comparable to other work with children certainly could be relevant. And here, since it was the forensic interviewer had over 2.5 years of experience as a forensic interviewer, I think it is certainly relevant to show that those years she spent as a teacher certainly qualify as other work comparable with children to make up the difference in those 4 months. I think it's also significant that she was a teacher. I think that's consistent with the way the statute is written when it specifies, I believe it's 6 types of bachelor degrees that you have to have. And all of those align with the work experience in subsection C, but the only difference is education is one of the bachelor degrees that is permissible for you to have to go on your way to becoming a forensic interviewer. So the fact that the legislature specifically designated education as one of those majors seems to indicate that work as a teacher would in fact be work with children that's comparable to that of a forensic interviewer, and it would be enough here to qualify the forensic interviewer and for the trial court to find that she did in fact meet the statutory criteria and that the interview was thus admissible. And again, we had a chance for the trial court to hear the testimony of the forensic interviewer, hear her relate how her experience is as a teacher overlapped with her experience as a forensic interviewer. And since this is especially since this is reviewed for an abuse of discretion standard, there's nothing here to show that the trial court actually abused its discretion.
Is 150 years really the least restrictive measure?
That's what the trial court stated.
Well, I understand that's what the trial court stated. I'm asking you, is 150 years the least restrictive measure? I mean, 75, I don't remember how old the defendant is, 75 years, half of that. Probably going to be in prison for the rest of their life for horrendous crimes, don't get me wrong. But that's a less restrictive sentence, in a sense, still life in prison, basically. But 150 years is the least restrictive measure?
I certainly understand it's a long sentence, but again, since we're under that abuse of discretion standard here, we're looking at what the trial court considered, and it considered all of the appropriate factors here, and especially in the post-Bice, post-Pollard world, this court has affirmed lengthy sentences and isn't going to find an abuse of discretion simply because it's a long sentence. What we had here was the court making all of the relevant statutory considerations. It explained how it had weighed the proof that it considered at trial and how that fit into all of the statutory criteria here. And again, I very much acknowledge this is a long sentence, but the trial court made the appropriate considerations and specifically found that this was the least severe measure to ensure the purposes and principles of sentencing, and we would ask this court to conclude that that was not an abuse of discretion in this case. And unless there are any further questions, we would ask this court to affirm the judgment of the trial court. Thank you.
Rebuttal?
So first, to clarify Judge Hickson's point, in the record, there was testimony that the police captain who was communicating with the judge via text did exactly, hold up, this is going to be a bad case. We think there are more charges coming. So that gets back to Judge Dyer's question of when does that initial probable cause for maybe one or two offenses translate into the need to hold somebody or deny appearance before a magistrate in order to be admitted to bail or bond. Second, with regard to the qualifications for the interviewer, and I want to refer to my notes, because Judge Ayers mentioned something that Ms. Fuller defined what she believed the qualifications were for a forensic interviewer. It's in volume 2, page 21, and it's a structured conversation with a child for the purpose of eliciting as much information as possible in a neutral and non-leading way as possible to assist in furthering an investigation. So not unlike what we're trained to do on direct examination. The problem lies in the fact that everything that she testified that was comparable to the 5 professions that are listed in the statute, child service worker, criminal justice, counseling, clinical evaluation, or forensic interviewer, or if you read it the other way, just forensic interviewing, none of what she testified to rose to the level of the things that are required for that. She testified that she had, and I'm not making fun of light of what she said in any way or disparaging teachers, it's just 2 different sets of qualifications. Dispute resolution on the playground, and that she counseled students on right and wrong in the classroom. She also distinctly testified that she had no training as a forensic interviewer at the time she was a teacher that was similar to what she received in her current job. And she never, as a teacher, had to make a report to child services, to a law enforcement officer, or to anything else that led to an official investigation. So her training and time with the Child Advocacy Center was the sum total of her foray into this.
Well, let me ask you this, ma'am. Being a forensic interviewer, it seems to me, is a highly specialized job to have. It's difficult to think of things that are comparable to it. But when you look at the statute and you look at the specific professions that were listed, and when you look at the word comparable, and you read the statute in a way that gives it meaning and gives that word comparable meaning, what other jobs would be comparable to being a forensic interview, if not a teacher?
Well, I think it gets back to Ms. Fuller's statement. Any other job, like these jobs where they're doing investigatory work and they're trying to do it in a way that is fair and impartial to both the parent or anybody else who's involved, it's a neutral and non-leading conversation with the child. This court found in Clymer that that was adequate for someone who was a brain injury liaison at Vanderbilt, who was translating basically information from doctors to families and children about complicated issues and what's going on. We're not privy to the full amount of what she testified to for qualifications there, but it's got to start at that root definition of neutral and non-leading questions. Things that would be comparable, that's probably going to be up to the court ultimately to decide. But what the trial court found here is what's important, and it found that she communicated with children, that her experience did not have to be identical to forensic interviewing or counseling, that she had full-time experience with children, and the trial court said, you're talking to children, you're making them feel better, and you're solving their problems. And none of that gets to Ms. Fuller's definition or anything else that's listed in that statute.
But to the question I asked earlier, and kind of using Judge Hickson's question as well, I mean, it's not like she had no training.
Correct.
And so, yes, if she were just a kindergarten teacher and had no training, your argument is a lot heavier, makes a lot more sense. But with 2.5 years of training and this experience of conflict resolution with children, speaking at their level, this, that, and the other, doesn't that kind of help the comparable language?
I would agree that she is very close, and that the 8 months probably could be a factor in that she's had. How much of the comparable experience is going to be necessary? Like you mentioned, can it be a full 3 years? No. Otherwise, there would be no need for the statute to exist if you are just talking to children, and that is comparable to that.
Well,
But
there's a reason for the statute to exist.
Correct.
I mean, I get your point, but it's not like she was a ditch digger and they're trying to somehow make ditch digging and 2 years and 8 months of forensic interviewing somehow comparable.
No, but what is problematic, the state characterized teachers in its argument in support of finding that she'd bridged that gap for experience. She was described as a super parent. While parents interact with their children, there's a difference between asking your children neutral and non-leading questions that are going to be used for a Class A felony and finding out who broke the vase. And that's got to be, in light of the seriousness of the offense and the cases that this used for, that has to be taken into consideration. And to the state's point, if the court will allow, the state mentioned that McCoy doesn't implicate the rules of evidence, and if I'm putting words into the state's mouth, then disregard. But there was a point that the rules of evidence are not implicated, and that the state is required, almost portrayed as something special, to authenticate something twice. Everything that comes in or is discussed at pre-trial is authenticated twice. If there's a DUI video that's reviewed for a suppression issue, that doesn't relieve the burden of the police officer having to authenticate it for the jury. Because the jury's a trier of fact. The judge just makes the determination of whether or not that gets to the jury for their consideration. So everything is authenticated twice. I don't see that as requiring the state to go through an additional hoop. It's just here with McCoy and the statute and the rules of evidence that 24/7/123 is becoming a part of. It has to fit into that canon of it's an exception for the hearsay because it's statutory, and it's still got to meet the authentication requirements. And here it just says that it's got to be this particular person. From State v. Cannon, 254 Southwest 3D 287, which is a Tennessee Supreme Court case. Put another way, a witness must be able to identify the evidence or establish an unbroken chain of custody. So we're not asking the state to authenticate it twice. It's just every other piece of evidence comes in that way, and it shouldn't be any different in this case. And for that reason, we'd ask this court to reverse and remand.
Thank you.
Thank you.
call the next case, please.